Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Hello, you're welcome to Hanging Out with BWF Solicitors. May I say good morning, good afternoon, good evening, depending on wherever you are watching us all over the world. I hope you are all keeping well. Welcome to this program. Today, we've come your way with another interesting topic with my resource person in the name of lawyer Eunice Achampong, a partner and also a solicitor at BWF Solicitors. We will be discussing this topic, cases where you are not required to submit a valid human rights online application. May I also say that BWF solicitors are specialists in immigration and nationality, family law, dispute resolution, and Ghanaian law and practice. At the end of this program, Lawyer Eunice will be able to give you her details if you wish to contact her. If you like to, contribute to this program or ask a question, you can do so on all our social media handles, Facebook, YouTube, Instagram. We are live on Facebook at the moment, and all social media handles, if I should say. So you can send your comments, to us, and I'll be able to pick that question or comment up. If you prefer to call us live in the studio, you can do so on 0744-8619-711. The number again is 0744-8619-711. May I also and ask you to share this live broadcast, because it's really benefiting a lot of people. So the more we share it to our contacts and colleagues and anybody else that you believe this program will be of benefit to, please do so. Let me quickly introduce lawyer Eunice Achampo. Hello, lawyer Eunice.
Hi, Vicky. How are
Yeah,
you?
how are you?
By God's grace,
Good,
I'm
good,
doing well.
good,
How
good, good,
about you?
good, good, good. I'm fine, thank you. I'm fine. How was your week? I know all
Busy?
this acting, right?
Busy, but good.
Mm,
Yes,
mm.
yes.
Okay. Any updates before we talk about today's topic?
Yes, of course. So, as we all know, in terms of our immigration, there's always things that are being updated and policies and guidance. So, for this week, they have introduced a new policy guidance.
Yeah.
They call it a concession. So, usually, a concession is something that has not been made secondary legislation or law yet. So, it's something that they are willing to put forward and basically willing to give if anybody falls into that particular category. And so for those who are children, or should I say, who have lived here more than half of their life and are under the age of 25, they have this concession to grant them more, or should I say, an extended leave than 30 months. So we all know that usually they will give you a 2.5 year leave if necessary, or if you are requesting for a longer period of leave or indefinite leave, there are certain criteria that they will look at in terms of the request you've made. And so, if, for instance, you are making an application for leave to remain, and we all know that private life applications can be made if you are under the age of 25 but have lived here more than half of your life, or you're above the age of 18 and you've lived here for at least 20 years, or you're a child who has lived here for a continuous period of 7 years and you are under the age of 18. So this is relevant to those who are under the age of 25 and have lived here for more than half of their life and want an extended period of leave, or they want an indefinite leave to remain. So in that case, their policy guidance is they have to look at things like if this person has an existing leave to remain, they have to look at the person's strong connections here in the UK. They have to look at the age. They have to look at why the person is applying for an extended period or indefinite leave to remain, their family background. They have to look at other factors why this person should be granted longer leave than they are necessary is necessary, or why they should be granted indefinite leave to remain. And because it's a high threshold, so I'm believing that apart from the fact that somebody may have valid leave already, they would also have to have strong reasons. So it might be that um, they are unwell and maybe they need to be granted indefinite leave to remain because, for instance, maybe they were previously under our derivative rights, and as a dependent, you can't be granted derivative rights above the age of 18. So maybe because of that, they were not able to apply for indefinite leave, and therefore, because of that current situation, they may need indefinite leave to remain. So situations like that, and obviously it's a case by case scenario. And so it's good news for people who may have that situation and may want to apply for indefinite leave to remain after a long period of time. And so let's see how best we can use these policy guidance to benefit people who are under this category. So, yes, just a little bit of good news for our young people as well.
Mm, mm. No,
Yeah.
Eunice, I'm just wondering, are we live on Facebook?
Yes, we are.
Okay. All right.
Yes,
Wonderful.
we are.
Right. Ladies and gentlemen, as I said, you can join us live on Facebook. Send in your questions. If you have any comments, you can also, put it on the platform. Laura Eunice, today's topic, tell us a little bit about it.
Yes. So usually, most people would say that if I can make an application and
Mm-hmm.
pay the fee, then I'll go ahead, make the application. But then there are certain cases, or shall I say, there will be certain cases where a person will not necessarily have the opportunity to put in an online application. And if they don't have the opportunity to do so, then they need to be able to basically have something afforded to them. And so, if you know that you have human rights and you can basically let the Home Office know that you do have human rights claims that you can make, and therefore, because of your human rights claims, you want
Mm,
them to be aware that they can't just remove you, or they can't just um, detain you for a long period of time without granting you bail, for instance, or they can't just put you in limbo without making sure that you have been given some sort of immigration status to remain here in the UK. And one of the, should I say, the legal um, factors that really pins this down is Section 120 of our Nationality and Immigration and Asylum Act. And so, with that, you are allowed to make further representations based on your human rights, or your what we call protection claim. So,
okay.
people who may have made asylum claims or refugee status claims, all those people come under that. And so it's important that, as much as possible, if you cannot put in a proper application, you know that there are ways and means by which you can also make further representations, so that at least, whatever the case is, you can also make the Home Office aware of your human rights, and then they can consider those and assess the evidence that you will bring forward in terms of something that you believe should be made aware of.
Oh, okay. All right. So what is a valid human rights application?
So usually, if you look at our immigration rules, you would find out that in terms of our human rights applications, those who fall under categories such as a private life application, like I mentioned earlier on,
Mm,
and those that fall under our human rights application in terms of them having a spouse or a partner or a child who is either British or settled here in the UK,
yeah.
they are the kind of people who would be able to make a human rights application. And then also, when you talk about making a valid application under our immigration rules, it means that you are making an application using the appropriate form. You also need to have your biometrics done. So, with every application that you make, you need to have your biometrics taken as well. And then you also need to pay the correct fee. So, every application comes with a fee. You will need to pay the appropriate fee for that application. And then, of course, you have to make sure that you provide a valid form of identity. So, you will be able to show that, yes, I have, let's say, Nigerian nationality, and therefore this nationality is what I've provided with valid means of making this application. So when you're making an application, you fill the form, you pay the fee, you have your biometrics taken, you provide your valid passport, and
Mm,
that's what a valid application is. But in this case, we are not going to be looking at that. We're going to
okay.
be looking at what it is not to have a valid application made. Yeah.
Okay. All right. Ladies and gentlemen, if you've just joined in, stay with us. This is Hanging Out with BWF Solicitors. I'm your host, Vicky Newton, and with me is my guest, a partner and also solicitor at BWF Solicitors, Mrs. Eunice Achampong. And today's topic is cases where you are not required to submit a valid human rights online application. You can join in the discussion or send in your comments on all our social media handles. And we are also live on Facebook. We would love to hear from you. If you prefer to call us live in the studio, you can do so on 0744 8619 711. The number again is 0744 8619 711. Right. Laura Eunice, what criteria has to be satisfied when lifting the no recourse to public funds condition?
So, in terms of no recourse to public funds, usually if you are making an application for no recourse to public funds, you have to make sure that you yourself have assessed that you are not somebody who is destitute. But if
Mhm,
you are at risk of being destitute, then you should be able to provide evidence in that form. So, for
mm,
instance, you are saying that currently you don't have a means of living at your current accommodation. So now that you have um, lived with this person, the person says they will no longer accommodate you. So you can't rely on this person accommodating you and your child for a very long period of time. So when
mhm,
it comes to things like that, you have to make sure that you are currently saying to yourself, if I were to put myself in this situation, if, for instance, the next 3 months, this person says they are checking me out, myself and my children, we have nowhere to go. So maybe you might need this person to provide you with a letter to say that, unfortunately, you cannot stay at their premises. Or, for instance, you look at your income and you're thinking to yourself, unfortunately, I cannot allow myself to keep going like this. Maybe I'm paying for all these expenses, I'm paying for A, B, and C, but unfortunately, my income is not enough to keep paying for these expenses. So you have to make sure that you are not overdoing it. So if you think you are at risk of not being able to provide for your income, you're not able to provide for your children, for instance, then definitely um, things like that should be made known. So if you're at risk of being destitute, you can't provide your accommodation, you can't provide for your essential needs for yourself and your children, or you feel that your income is so low that you cannot be able to keep meeting the expenses that you have, then please, of course, you have to show evidence and make them know that this is something that you cannot keep doing. And so you have to also have evidence to back that up.
mm,
There will be circumstances like we discussed last week, and so there will be circumstances where you will not be able to obviously provide enough evidence that you are financially stringent. So, for instance, you are somebody who has a joint account and your partner is being abusive, and so unfortunately, you cannot provide evidence in
evidence.
regards to bank statements, but there are other evidences that you can provide to show that unfortunately you will not be able to meet expenses. And if people provide you handouts here and there, they can also provide supporting letters as well.
Okay. Laura Eunice, is there a difference between exceptional financial difficulties and just financial difficulties?
So when it comes to um, exceptional financial difficulties, of course, you have to look at the fact that um, when it comes to things like this, it is important that you realize that all these things come because maybe you've lost a job, maybe you're on furlough, maybe it's because there are um, things that have made you lose your job. So unfortunately, maybe you were not well enough to continue in a job, and so
Yeah.
you've had
Okay.
to let that job go. So
Mm-hmm.
you have to obviously look at the fact that there might be reasons why your income has dropped. So if you are struggling, it might mean that because your child has become ill, you can't work the way that you used to work. And so they have to consider all of these things when they are making their assessment. So yes, your financial circumstances have changed, but why has that come about? What change are you referring to? Is it because of the fact that you have this situation where the person has lost their job, their income has dropped so much that their expenses have risen. So you look at things like rents, bills that have to be paid, things that come in terms of paying for school dinners, paying for extra tuition, and those other things. And if you feel that because of your current situation, there's no way that you can pay for even things like the normal day to day shopping that you have to do,
Yeah. Yes.
they will have to consider all of that as well. And so it's important that you realize that if you are facing such financial difficulties, then it's important that you let them know that this is what you are facing and
Mm,
this is what needs to be done in regards to that situation. So
okay.
it's important that we obviously look at all these things and then um, make them aware of it, because you have to be able to provide them with evidence of your financial circumstances, which include your bank statements, your
Mm,
bills, your current income. So if you are receiving pay slips, you will provide that as well. And then you have to obviously keep letting them know, and
mm,
then they would obviously make that assessment as to whether you should be provided with some form of benefits, or they should lift that condition of no recourse to public funds.
okay. All right. Yes, Lawyer Eunice. A quick by saying that I have three children and live with my partner who was granted 2.5 years about 6 months ago as a parent. I also have 2.5 years which will be coming to an end in 3 months' time. I do not work, but my partner does. And still the income he receives is not enough. What do we need to have?
Sorry, Vicky, if you just check the comment
Right.
below.
Okay. So should I hold on to this question and read the
Yes,
comments on
please.
Facebook? Right.
Yes.
Just bear with me 1 second. Right. Um, I've only seen one comment from my end.
Yes.
And that comment, oh, okay. Right. 1 second. Let me check. Oh, okay. Right. Okay. Right. Okay. Right. So I've got it right now. I put in my apologies. I put it in an asylum claim about 5 years ago and granted an application card to be able to claim certain benefits. I have not had any response, and have I would have lived in the UK for almost 20 years and would like to know if I can put in an application, Laura Eunice.
Okay, so in terms of somebody who, for instance, has made an asylum claim, and usually if somebody is putting in an asylum claim, they would have done that early on when they entered the UK. So, for instance, they believe that their life is at risk, or because of their political
Mm, mm,
affiliations and whatsoever, they
mm,
believe that if they return to their country of origin,
mm.
maybe their lives will also be at risk of um, being put to death, or they will be tortured and the rest of it. And
Yeah.
so, of course, if you believe that um, you have come to the UK and you would like for them to be aware that this is the current situation in which you find yourself, and therefore you need to put in an asylum claim, you
Mm,
need to declare that right at the time when you enter the port or you enter the UK. And so most people who find themselves in that situation would put in an asylum application. And once
okay.
they've put in an asylum application, it takes time. So they would usually call you to an interview to question you. They would then also grant you an application card for you to be able to access any form of benefits or public funds, to be able to look after yourself. And so, if a
Okay.
situation like that were to occur, it would take them time to obviously assess. And I was reading on one of their publications that a lot of asylum claims, um, they said over 20,000 asylum claims have still to be decided. And so
Decided. Mm,
it means that a lot of people who have made these applications are still waiting for responses to be able to know the way forward. And so if you are one of those persons who has put in some
mm,
form of asylum claim, and now your situation has changed, like this person who has asked the question in regards to
okay.
their asylum claim, they're saying that they would have lived here almost 20 years. And if you have lived here for a period of 20 years, you can make a valid private life application. And most
Right.
people would know that. But where you already have an existing claim, which is an asylum claim with the Home Office, you don't need to provide them with another application. So
Yeah.
you are saying them to them that your circumstances have changed. Now you have lived here for a period of 20 years. And so you have to provide evidence to them to show them that you have lived here for a period of 20 years. So if,
Yeah.
for instance, you made the asylum claim almost 20 years ago, of course, they know that your um, evidence is there that you made this claim at that time. And you
Mm,
need to provide them with further information. So maybe you went um, to them for further evidence. And so maybe 2 years down the line before you came, they had further evidence that you were still in the UK. But it is up to the applicant to provide them with the information or the evidence. So if you've made a previous asylum application and they have still not made a decision, then it is up to you to say that, here, see, I have evidence from um, places like shopping centers that I go to, Tesco,
mm,
Sainsbury's. I have evidence from my GP. I have evidence to show that maybe I was working here and there when I shouldn't have been working. You can provide all of those as well. I have evidence to show that, for instance, I was able to open an account. I have evidence to show that maybe I was able to also get a credit card or some shopping cards. So if you have evidence to show that you have lived here for that 20-year period, all you need to do is to make further representations to them to let them know that currently my circumstances have changed. I have
mm,
lived here for a
mm,
period of at least 20 years. This is the evidence to show that
mm, mm,
this is the period of time that I've lived here. You've probably formed strong social ties. Maybe you're an active member in your church. You go out for outreach programs, or you do community things. So you include all of those as well in the application or in the further representations that you are making to the Home Office, and
Okay.
they would assess that evidence that you have brought forward and see whether they can now grant you further leave to remain. And so
Okay.
that cuts the cost, it cuts you having to now provide a valid passport, for instance, but at some point they may ask you to provide a biometrics just because they will be asking you to have a biometric card. So in situations like that, you
Mhm.
would be able to cut out some of the things that a valid application would require. But as long as this person is able to provide evidence that they've lived here for a period of 20 years,
Yeah.
then of course they can provide that to the Home Office when they are making those further representations about what their current circumstances are.
Okay. Lawyer Eunice, Nana is asking what are some of the example of cases where it will not be necessary to submit an application?
So, for instance, in this person's situation where they said they had an asylum claim,
Yeah.
then that is a case in which you can say that, yes, because I have an existing asylum claim with the Home Office, that would be an example of a case where you wouldn't need to provide a valid or current online application to the Home Office.
Mhm. Yeah.
And then, of course, you have situations where, for instance, a person has been detained and they are asking for further representation. So, what we usually call a Section 120
Yeah.
notice. And so, you would be able in that situation to provide further representations to the Home Office regarding that person's detention, for instance. And so, if that person, for instance, has lived here for a period of 20 years and you want to make a claim on that basis, you could make a claim that yes, this person has human rights and this person unfortunately cannot be removed from this country because of A, B, and C.
Yeah.
And so if a person is currently in detention, they too can also make further representation without submitting a valid online application. Or, for instance, in certain situations where um, a person has been refused and then they've gone on to have an appeal, and the judge believes that maybe um, they have a right that they didn't have before. So I remember one of my clients was in this situation where we had gone for a hearing, and this one was a judicial review hearing. And at the time that the judicial review was being submitted to the court, he didn't have a child with his current partner. And so, as the hearing went on, we made clear to the judge that he now has a child with his current partner. And so the judge said to the Home Office representative, well, I think that it's up to you to now consider his relationship, his parental relationship with this
Mhm.
child. And then, of course, we can go on from there. So, in situations like that, if the Home Office is in agreement to have to consider the parental relationship that this person has with that child, then of course it will be like that person is making further representations
Mhm.
at that point to the Home Office and let them know that this is what um, they have in regards to the relationship they have with the child, and therefore that should be considered as well. So obviously in that case you would need to agree, the judge would need to agree with the Home Office because they are the ones that would have to consider and assess
Yeah.
the parental relationship with that child. So yes, there are those cases where you would need the Home Office or you would need the representative to be made aware that these are your current human rights claims and you want them to be aware of it. So those are the three main areas where I believe that a person can make representations without having to put in like a valid online application.
Okay, right. Ladies and gentlemen, if you've just joined us, this is hanging out with BWF solicitors. Today's topic is cases where you are not required to submit a valid human rights online application. With me is Mrs. Lawyer Eunice Achampong. She's a partner and also a solicitor at BWS Solicitors, who is taking us through this topic and also um, answering some few questions, giving us more explanation on this topic. If you want to contribute to the program, you can do so on our social media handles. We are also live on Facebook at BWF Solicitors. If you like to call us live in the studio, you can do so on 0744 8619711. The number is 0744 8619711. So please send in your questions, send in your comments. We'd love to hear from you. As usual, I'm your host, Vicky Newton. Lawyer Eunice, this person wants to remain anonymous. She doesn't want me to mention her name, which I will respect. She said, I've lived in the UK almost all my life and came with my brother and sister when I was 9 years old. I had my son about 2 years ago. I'm currently in detention as I came out of prison about 4 months ago. I was sentenced to 3 years in prison for being in possession of a class A drugs. I need some advice on what I can do. This is a very sad one, isn't it?
Yeah, yeah. And of course, she's saying that she came here when she was pretty young, and
Yeah.
this this is a situation where a lot of us who have, should I say, brothers and sisters, or who have aunties and uncles
Mm-hmm.
who came with their children, or who had our cousins come here when they were pretty young, we see that, of course, if they didn't have British citizenship, then of course they will be seen to be foreign criminals because they still have Ghanaian nationality. Even if they have indefinite leave to remain, it will
Yeah.
still be seen as somebody who is a foreign criminal because they don't have British nationality. So, in a case like this, where she has been put in detention, and usually they would remove you from prison once your sentence has been carried out and place you straight into detention if um, the Home Office believe that obviously you are a foreign criminal and you have committed a criminal act for which you have been sentenced to a period of 12 months or more.
Yeah.
And they would put a deportation order in place because they will see you as somebody who is not fit, or who is not shall I say, somebody who should continue to remain in the UK because your conduct and your behavior shows that you have no regard to the law.
The law.
So, of course, if you are somebody who is seen to be a foreign criminal, the first thing that the Home Office will do will be to issue liability for deportation order right as soon as your sentence has ended. And so I remember very clearly one of my clients telling me that being in detention is like the worst thing ever. And he would prefer to go back to prison. And I said to
Oh
myself,
no.
yes, because it's that bad. I think obviously the conditions in detention centers are not great either.
Okay.
So he said to me, no, 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 no. And unfortunately, you find a lot of people in this situation as well. So for her, it's sad because of course you have somebody who has a child as well, and so it's not as if she's currently childless. She also has a child here. And so if she has a relationship with this child, then she should be able to provide evidence in regards to that. So, of course, um, she's saying that her family life is here. So I'm guessing that maybe her parents are here, her siblings are here, and then she also has her child here who maybe she has a relationship with. I don't know what her circumstances were before she was in possession of this class A drug. I don't know what her current physical or mental capacity is.
Yeah.
So, of course, if she is saying to the Home Office that I have a child here, I have uh, a bond with this child, I am currently somebody who obviously sees my child whilst I was in prison, maybe during that period of 3 years, I was seeing this child. Maybe it might be that she constantly has phone calls with this child, so this child knows very well who their mother is. And of course, if it's is the case that this child often comes to visit, I don't know whether it's every week or every month, depending on the regularity of this child visiting her mother or his mother, then of course they would consider that as well. And so, if, for instance, she's saying that I have a parental relationship with the child, I think it's best that somebody who is uh, should I say, certified social worker will then examine and assess what the relationship is like. Because for somebody who's been in prison for that long, it might be that they will need some further evidence to provide that this is what they believe to be a person who has built some sort of emotional and attached a strong attachment to this child, and so that should be put into perspective, of course, in terms of the representations that they are making. And then of course, if this social worker is also able to provide evidence as to how this child also feels about their mother as well. And then in terms of providing evidence that maybe this child also would like to see their mother come and support her more and all of that. So I'm not sure what the age of this child is now, but if they are young, their views can be considered. If not, then of course it would mean that they will have to, the social worker will have to assess what the situation is like for both mother and child. And then you also have to consider the person's background. So before she went into prison, what was her life like? Was she somebody who was a persistent offender? Was she somebody who was constantly doing what she was doing? Or did she find herself in this situation because of some sort of hardship? So was she somebody who went to school? Was she somebody who was working? All of those things can also be considered as well. So, of course, like I said, if somebody has private life built up here in the UK, that is also a human rights application. And that in itself can show that, well, this person has lived here for a period of, let's say, 20 years or a period of more than half of their life. And that should also be considered. Um, if she came here and she was granted indefinite leave with her siblings, then of course you would also say that this is somebody who was granted indefinite leave to enter and had some form of indefinite leave. And so, yes, she was somebody who went to so and so school. She had so and so qualifications. She was working. Unfortunately, she found herself in this situation where she is unable to provide, and that's why she started dealing with drugs. And or maybe she found herself in a bad relationship and it was abusive. She started doing as she was told. So you have to look into the background of the person who is saying that they want to make a claim based on their human rights to the Home Office. And so all of this will also be included in the assessment. And so you want to bring out the best factors in a case like this in terms of them making this application or making these representations to the Home Office. And so the background of this person, the parental relationship that they have with this child before they even went into prison, and what it is now currently, and then all of those other factors which show that they have that strong bond. And those things are what we call mitigating factors. So aside from the fact that she's been to prison and she's liable for deportation, these are the factors that we believe should also be considered or assessed when making further representations. And so the Home Office are likely to consider these things as well. Even grant her bail or continue to say that, okay, because you have made these representations, we will go on to assess whether you should be granted leave to remain, or your existing indefinite leave to remain should be so. So all of these factors also help in their assessment.
Okay, so if the claim is refused, does this person have the right of appeal?
So in fact, if you make any human rights claim or representation, yes, you will have a right of appeal, and that's very clear from our Immigration Act of 2014,
Mm,
which shows that, of course, if you make a human rights claim and you believe that, for instance, whatever protection claim, so protection claim can be either an asylum claim or somebody who's made a refugee status application. Those categories of people can obviously be granted a right of appeal because of the fact that they have made such claim, and therefore, by law, they would have a right to appeal. And so, if for one reason or the other, the Home Office says that we still cannot grant to further leave, or we still
mm,
do not
mm.
believe that you should remain in the UK, then you will be given a right of appeal, where the courts will be the third party, or should I say, the just and fair um, arbitrator to listen to your case and then
Sure.
see the evidence that you have and
Mm,
assess whether you should be granted leave to remain.
okay. No, it really is. This is a personal question. I
Yes.
wanted to know whether they are more lenient with women, as in this scenario of this lady being in prison for four
Yeah.
months, as compared to men.
Do you know what? I would like to say that the law doesn't discriminate against male or female. And of
Okay.
course, if you find yourself in this circumstance, and well, we say that women are very good caregivers, and so with women, we are
Especially when
able
children are involved.
yes, we are the ones that get more involved when it comes to childcare and the rest. And I don't know whether it's a sex thing, but there are some males that are very interested in their
Yeah,
children's lives, and
yeah.
they will go all out for their children. And unfortunately, there are some that are not so caring, and so I
Okay.
wouldn't say that it is the law that is at fault. It just depends on the person. And if you
Mm,
are somebody who is able to show that you are a person who has formed that bond with this child, who is basically being there for this child as and when,
okay.
then there will be no way that the law would discriminate against you. And so it all depends on the evidence that you bring forward. And like I said, if a
Okay.
social worker has to provide evidence and they realize that, well, this child has really bonded with their father, then
Mm,
of course they will put that in there and they will make sure that they
okay.
address it as it should be. Yeah.
Mm, mm. All right. Lillian, have you got any questions from your end?
No, not
Okay.
not at the
All
moment.
right. So, in the absence of any more questions, if we could just summarize what we've discussed so far, and
Yeah.
also leave your details for anybody who would like to contact you for further advice.
Okay. So yes, we've been discussing where cases where you wouldn't require a valid application, and that includes cases where an asylum claim has been made, or where you are currently held in detention, and very rarely in appeal cases where, for instance, the judge has asked for the consent of the Home Office so that somebody who has human rights claim can put that forward. And so, in those cases where you have lingering asylum cases and you think that your circumstances have changed such that you probably have formed private life, or you have a parental relationship with a child who is British or settled, or you have a partner here in the UK,
Mm,
um, before your obviously your current situation existed, you were able to show that you've also lived here for that long period of time,
mm,
then you can provide evidence to say that you are somebody who has lived here for a period of 20 years, or you're somebody who has formed a relationship with a child, or you have also formed a relationship with somebody who is British and you have a family together with that person. All of those things can be made known through further representations to the Home Office. And that in itself is your, should I say, your application to the Home Office, where you don't have to pay a required fee,
mm,
you don't have to provide a valid passport if your details are already with the Home Office. And so in that situation, you are making known to them that your circumstances have changed, and therefore they should consider or assess those circumstances and grant you further leave to remain. And so, if you find yourself in that situation and you believe that you can make an application because of your current circumstances, then of course you do not hesitate to contact us. Um, Very, very rarely do I see people in this situation, but if you do find yourself in this situation, don't hesitate to contact us. I will put down my number, but I will give the office details now. And so, as Vicky said, we are BWS solicitors and we are situated in London. Our address is the fourth floor of Anna House, 214 to 218 Tottenham High Road.
mm.
And we are in London. Our postcode is N154NP, and our office telephone number is 0208 493 7340. So I'll repeat, that is 0208 493 7340. And we open from 9:30 a.m. to 6 p.m. My current number is 07535813910. So 07535813910. I know that people are still asking questions,
Yeah.
and you can call me after the program, and then of course we can take it from there. And yes, I will leave that to you, Vicky.
All right. So, ladies and gentlemen, there you are. Our guest, lawyer Eunice, who is a solicitor and also a partner at BWS Solicitors. She's left her details for anyone who would like to contact her for any advice. Bear with me 1 minute. Hello. Good morning. Fine, thank you. Okay, you want to ask lawyer Eunice a question? Okay, hold on a minute. 1 second. Hold on. Lawyer Eunice,
Hi.
would you like to answer this gentleman's call? I don't know.
Okay.
I'm just rounding up.
Yes,
Right.
that's fine.
Okay. Hi, caller. Yes. Lawyer Eunice is happy to hear your question.
Okay, all right, thank you. I just applied for a previous month. I just applied for a pre-statute, but I just got a review from the Home Office, and I just do administrative review, and I got the email that they have accepted my application. They're gonna review my application as soon as possible, and I'll get the feedback from them.
Okay.
It's been, I think, almost 3 months now. I haven't heard anything about them.
Okay.
So what can I do?
Okay.
So
All right.
in terms of the administrative review, I know that usually they're supposed to make a decision within 28 days, but unfortunately, due to the current circumstances, they say they will not be able to make a decision within that time frame. So I remember making a PAP in regards to one of my clients, and the PAP response was, unfortunately, there is no way that they will be able to meet their standard period of service because they have just had an influx of people making administrative review applications since January of this year. And so they will try and make a decision as soon as possible, but they cannot give a time frame in which a decision will be made. And so that was the response they sent to me. And I said to myself, oh my goodness, they can't even give a time frame, but they will try and make a decision as soon as possible. So I think that unfortunately, due to the current circumstances and the fact that during last year's lockdown, a lot of them were working from home, and a lot of them could not even access their workload. So it has just built up, and therefore they are not able to respond within the time frame that they would usually have responded in. So you will just have to be patient and wait.
Okay.
All right, thank you.
All right. So just be patient.
At the
Yeah.
moment,
Yeah.
I just got a new job. I'm trying to apply for a DBS, but they are asking me about my pre-statute, and I don't have it.
Do you have a certificate of application?
Yeah, I have the certificate of application before. I get the outcome of that.
Okay, so usually with a certificate of application,
I get the administrative review, and they said they accepted my application. They will review it and get back to me. I haven't heard about them almost 7 months now, and I get a new job, but I'm trying to do a DBS, but it's not accepted.
Okay, so
my pre-status before.
Okay, so Lawyer, what he's saying is that with the application itself, he got an acknowledgement, but because it was refused, he went for the administrative review, which they only gave him an acknowledgement letter. DBS is not accepting the acknowledgement, but it doesn't state.
Yes, okay. So in that case, usually they wouldn't accept it because, of course, they see it as you've been refused, and therefore they are still currently assessing your rights to remain here in the UK. Yeah. So if that is the case, you would have to wait for a response from the Home Office. I don't know if it's for pre-settled or is it for settled status?
It's for pre-settled.
Pre-settled.
Oh, so you've never had any residence card before?
So, Laura Eunice, how is he going to get a job to survive then?
So usually, if this is a person's first time of making some form of application, so even if it's for leave to remain in the UK, if you previously did not have leave to remain, it makes it difficult because you can't rely on Section 3C. So you can't even say that your previous leave is still continuing. And so that's what makes it difficult because you've never had leave before. And so it means that you have to wait for a response in terms of this current application before you can even apply for a job. Yeah.
Okay. All right. I wish you all the best. Yeah. I hope they will get back to you as soon as possible.
All right.
Okay. All right. Bye. Bye. Wow.
Yeah.
Wow.
Yeah.
Oh,
makes it difficult. I know.
Very difficult.
Yeah.
Well, ladies and gentlemen, on that note, we've come to the end of the show. If you have, any further questions or any concerns, Laura Eunice has left her details for you to get in touch with her, and she'll be very happy to assist you. She's got a team behind her as well, who are there to also give a helping hand, make sure that you are looked after promptly. So, on that note, take good care of yourself, and please remember, next week we'll be here live, bringing your way another interesting topic. If you mix most part of this show, we have the recording on BWF Solicitors Facebook, which you can go back and watch from the beginning. So I think if you just join us halfway through the show, you've not missed much. You can still go back and play the recorded version on BWF Solicitors Facebook page. So, ladies and gentlemen, yes, have a lovely weekend, and I hope to see you next week. Take care. Bye-bye.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.